sufficient evidence to find you guilty, and at this time finds you guilty of possession of a controlled substance, sentence you to a term of 18 months in the state jail prison, you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. In the 32518 and 32806 was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer, and then was placed on probation July 12th of 2021, and the clause number 21-36615 for 5-year deferred probation for state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor. Everything that we have in there is very direct in support.
All right. Thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right. Mr. Kimler?
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in a pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them, so that says something. It looks from a pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering her, about her to consider something at the lower end. She does have children. I'm not trying to use that as an excuse or anything, but they could maybe perhaps...
Children she was on her way to get while she was under the influence of PCP?
I know that they established conclusively that she was under influence. I mean, again, it reflects the substance abuse problem, but she does...
played true to all of the counts.
But yeah, that's true, Your Honor, and it reflects her continued struggle with substance abuse.
Yeah.
And so the issue, is going to be probably incarceration, but I would just ask that it be something not extreme, at the upper end. You know, she wanted to address it.
I do take accountability for my actions, but however, I have completed ISL before, and if you'll be willing to work with me again, I would appreciate it. I have, before I was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Brousard when I got assessed, and I was taking AA classes as well. I did complete 5 of the classes. However, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first possession, and I do pay my...
So is the time, it was told, I mean, because of the motion. So yeah, I mean, you did the 5 years, but
Yes.
it's not over.
Yes, ma'am.
What is, Ms. Malfino, do you have any position with regard to specifically punishment in these cases?
Sorry, Judge, I was just looking back at the original PSI.
You have them?
I do. Thanks. Obviously, the court sees that she doesn't, prior to this, have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
So, Ms. Brousard, you've been given the opportunity of, it looks like you went to Franklin North way back in 2017, and then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs. And you were, in fact, in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what they did.
So, but here's, okay, how old are you?
I'm 42.
Okay. So you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So at this time, in cause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. This time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody that the law gives you the right to receive. And then in cause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk with Mr. Kimler.
Right here. And what is the statement? I'll wait on that.
It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that.
When do you find another file?
You hand her that one, and just the bottom copy off of that one, Mr. Kimler.
When can I go to time?
They'll do the judgments today, and it should show up in the computer probably in the next day or two.
It's the jail does not give us this information.
It's right now it hasn't been all calculated, so it'll be in the system in the next day or two. Once the clerk, she's in court right now, so she can't do it, but it'll happen the next day or two.
Brousard reacts with a quiet, "Oh man," as the judge reveals she's 42 years old and has battled addiction for years, despite endless opportunities. When it happens, the verdict: guilty on escape while arrested, 6 years. Guilty on assault on a peace officer, 6 years. Guilty on possession of a controlled substance, 18 months. All sentences run concurrently, meaning she serves them together. Not stacked, but 3 felony convictions land in a single, unforgettable moment.
Good morning. Are you Leroy Harris Jr.? And this is cause number 24 DCCR 0404. Mr. Harris is charged with the first degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in 2 cases on that same day. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term. And the murder case with a dismiss in the pending felony. What pending felony is there?
Drug case in there somewhere.
Well, that's the MTRP. So really wouldn't be a dismissal of it. It's just the MTRP on a state jail felony list. So I'm going to mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30. Yes.
Not 40.
Correct.
So is it okay? So Mr. Harris,
I don't think it makes a difference, but just the paperwork.
So the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket, and Mr. Burbank will begin preparation for trial.
Thank you, Annie.
Thank you.
Is that,
Yes.
And Judge, just may I, for the record,
Yeah, hold on just a second.
why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank. But it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you. All right, you can go back with the bailiff. Ms. Holmes here.
She just went next door.
This is set for
So obviously the case that Mr. Kimler's on is the one that would be the one that is set on the pretrial, and the other one is a new evading arrest. Ma'am, are you LaAsia Clemens? And Ms. Clemens is charged with robbery and cause number been hired on that one. Ms. Holmes represents her, but
Leroy
I would
Harris
think that the
Jr.
robbery would be
charged with
the
first-degree
issue
murder.
we need to take care of
The
first
judge
anyway.
reveals
So
a prior
Judge, I have,
2012 robbery
if I may,
conviction
spoken with
that
Ms.
could
Holmes
enhance
about
his
that
punishment to a
case.
staggering
Also would
range.
appreciate the
15
opportunity
years
at
up
this
to
juncture to speak
99
with
or
Mr.
life in
Kimler
prison.
again about the original
A plea
offer that
offer
she rejected
surfaces,
now that she has
briefly
been back
confused
in
between
custody
40
and has a new
30
felony.
years.
let me
I
hold
don't
that.
know
Before
that
landing
that
at
might
30,
not dispose
Harris
of everything.
rejects it
Otherwise, I will
sending
have
the
an
case
announcement
toward
here
trial.
very shortly.
Okay, I'll
Then a
hold it.
bombshell.
Y'all
He's
visit
already
real
been
quick.
convicted of a separate
And then
murder
we
in
also
Harris
have a
County,
sentencing on Ebony
adding new weight
Brousard.
to
Let's take care of
everything
that, and
he
then
has.
y'all. Number 25 DCCR 1339. Excuse me. That case is set for trial to begin with jury selection next Monday. There is another case of evading arrest or detention with the use of a vehicle. I don't show that you've been hired on that one. Ms. Holmes represents her, but I would think that the robbery would be the issue we need to take care of first anyway. So
Judge, I have, if I may, spoken with Ms. Holmes about that case. Also would appreciate the opportunity at this juncture to speak with Mr. Kimler again about the original offer that she rejected now that she has been back in custody and has a new felony. I don't know that that might not dispose of everything. Otherwise, I will have an announcement here very shortly.
okay, I'll hold it. Y'all visit real quick. And then we also have a sentencing on Ebony Brousard. Let's take care of that, and then y'all finish.